right, and then I'm going to turn it over to Jackson to get started. Jackson is here from the Citizen Advocacy Center to tell us more about the Freedom of Information Act. Go ahead, Jackson.
Great, thank you. I am going to make sure I can get back to my slides. Am I back the way I need to be? Awesome.
They look great.
Appreciate that. So yes, my name is Jackson Powler. I'm the community lawyer with Citizen Advocacy Center. Some of you might know the organization. A legal nonprofit based right here in Elmhurst, focused on civic advocacy, civic engagement, giving anyone who seeks it basically the tools, the knowledge, the capacity to get engaged and make their voices heard. And the focus today is the Freedom of Information Act. That requires a few disclaimers. Primarily, while this presentation will be fairly thorough, and although I do hope to get it done in under an hour, not including questions, by the very nature of what we're talking about, like this kind of presentation won't be able to cover every possible set of circumstances. I have to give some helpful background, some baseline knowledge, as well as some practical advice about what the law means, how FOIA works, and what to expect if you get involved in that kind of process. But again, this is not all encompassing. And again, this is for educational purposes only. Please don't consider any of this as direct legal advice that you can apply to a specific situation. If you want to get in touch about some sort of specific FOIA interest that you have, or really anything else civic advocacy related, please don't hesitate to reach out to me at CAC through the contact information on the screen. And right here, Alyssa, I might need your help with this one. I would like to ask if anyone here who has used FOIA before would be willing to share a little bit about either what your experiences are with it, or just some of the things that you hope to learn, hope to get out of this presentation.
So anyone feel free to post your experiences in the chat or post in the Q&A. And like Jackson said, just what you're hoping to get out of the session today. And also if you have any personal experiences with FOIA. All right, we have a question coming in. Yeah, coming in that you can't hear the speaker. So let's see, I'm able to hear him okay. It looks like he's unmuted. Is anyone else in the situation where they can't hear Jackson? Let's see. Are you able to hear me okay, Ellen? Let's see. Okay, so I hear from someone else that you can hear both. Good. So that kind of leads me to believe that maybe it could be a volume issue. I'm seeing coming up that Jackson's a little bit quieter. So Jackson, I'm not sure what you're using for a microphone, but whatever it is, do you mind getting nearer to it or turning the pickup up?
It's not very high tech.
Okay, gotcha.
I will
let's see.
Microphone audio settings here. I think I can turn myself up a little bit.
Yeah. And Ellen, if you can turn up your volume, I think between Jackson turning up his microphone and you turning up your volume, it should help us out a little bit.
Okay. I think I've turned my microphone up as high as it can go.
Oh, you do sound louder to me. So hopefully that works.
I hope that's enough.
Mm-hmm. All right. So, yeah, it's that someone else is saying that that's much better. So that's wonderful.
Good. Glad
Great.
to hear that.
I'm glad we got that out of the way right away. So just to repeat what Jackson was saying earlier, everything that is in this presentation is for educational purposes only. So none of it should constitute direct legal advice.
Although please feel free to reach out to CAC if you want to, if you either have something specific going on or just want to learn more. Happy to hear from folks in either of those situations.
Wonderful. And then if anyone can just share if there's anything that they hope to learn at the presentation today or experiences you've had with FOIA, just while people are thinking and typing. I will say that as somebody who works at a library, we are subject to FOIA. So my experience of FOIA has mostly been thinking twice about putting anything in an email that I wouldn't be comfortable with anybody reading. So anybody who works at a public institution, it's really good to keep that in mind, that, anything that you put in written documentation can be FOIA'd and read by anybody. So it's actually kind of a good thing, because it's a reminder to stay professional.
That is a good obligation to keep in mind. I would say the Illinois FOIA laws, it has some shortcomings, but it is pretty good. And as a theme I will hit a couple times during this presentation, the presumption, the default is that things are subject to disclosure. So anyone working on that side would be smart to keep that in mind, that unless exceptions apply, you will likely have to disclose most records, which again, I'll get to definitions of what records are. Melissa, if you can help me just keep an eye on the chat as we go. If anyone has any ideas about what you want to get out of this presentation, or specific questions, or God forbid I'm talking too fast and you want me to slow down on something, excuse me, I will do my best to keep tabs on the chat and the Q&A, but Alyssa will be there as well to help redirect me as needed.
Yep, I'll be keeping an eye out. So if anyone thinks of any experiences they've had with FOIA or things they want to get out of the presentation, pop it into the chat or the Q&A. But now I guess, Jackson, go on to the next slide, right?
As soon as I can get the slides to behave, here we go. Here's just I wanted to give a very brief roadmap that I'll get into a lot more detail, but there will really be three main buckets that the information I'm giving is going to fall into. What is the Freedom of Information Act? What is FOIA? What does it mean? Why does it matter? A little bit of the nuts and bolts, trying to be a little bit more bigger picture here in general, but we're still going to go over the nuts and bolts of how it works, a very abbreviated how to file a FOIA request, and the couple different things that can happen after a FOIA request is denied. So we're going to be coming back to this language on the screen a couple different times throughout this presentation, because this is important. What is FOIA? Why does a law like this matter? The way that I think about democracy, civic engagement, all the kinds of things that are in this world, is that democracy really relies on trust, and specifically public trust. Public trust is going to be a theme of a lot of what I'm going to be talking about tonight. And you really can't have that without some guaranteed level of transparency, some understanding that the citizens will have access to what their various governing bodies are doing, and have the ability to hold those governing bodies accountable. Freedom of Information Act laws across the country, including the Illinois one, exist to ensure that, at least to some degree, that happens. And the language in the bottom section, 140-3A, is the presumption. There will be exceptions that I won't get to, but the law does lay out a default that, all else being equal, the understanding is that public records will be available for inspection or copying. This is important because it defines how everybody, public bodies, citizens, courts, everyone should understand the law, and the presumption is disclosure. The default position is that public records are available and subject to disclosure. Why is this important? There's, again, I know I'm kind of repeating myself a little bit, but I think this is important, so it is good to emphasize. There is no trust without transparency or without openness. The Freedom of Information Act is a tool of trust, a tool of accountability. It eases accountability to know specifically what's going on, not just the results that you see. And that's what safeguards a lot of important parts for a democratic system, like freedom of speech, to discuss the government specifically, and the right to vote. So the important one important part to get to first is who is a public body, because public bodies are the entities that are subject to the Freedom of Information Act that must disclose public records, and the list is fairly extensive. There are a few examples on screen. The language in the Freedom of Information Act itself begins, all legislative, executive, administrative, or advisory bodies of the state, and goes on, includes counties, townships, cities. The default is going to be that a governing body is likely a public body for the purpose of FOIA. And again, I want to point out that last bullet point, this public body need not necessarily receive or spend tax revenue to be considered a public body. The important part is more the kind of authority that they exercise, what the responsibilities of that body is, not necessarily the funds that they're using to accomplish that goal. There's some strangeness when you get into like the judiciary. The Cook County clerk of court takes the position it's not subject to FOIA. There's you get a little bit more inconsistency there when you deal with the judiciary, which has different procedures and some different laws, although, as you see, some have directly incorporated FOIA procedures. And again, there's a difference between public bodies and public officials. Individual legislators would be considered public officials for laws like the Open Meetings Act, but they are not a public body in and of themselves. So anything related to state legislatures, the General Assembly would be the body there. So this is another fairly simple point about how the Freedom of Information Act applies, how broad it is, that not all work arranged by the government is actually done by government entities. Like local governments in particular will contract frequently with private entities to get work done, and the records created through that relationship are generally still subject to FOIA. The responsibility simply remains with the public body who has arranged the work or is otherwise responsible for those contractors to obtain the records if they are requested, and those FOIA requests still go to the public body, not the contractor, regardless of who has possession of those records. Again, the public body has the responsibility to go get them if they are requested. Coming back to this language again, because the 140-3 language at the bottom is going to be a piece of what we keep coming back to through this presentation. We defined public bodies, and again, if anyone has any questions about any of the public body definitions, please jump in at any points. I'm happy to address those. But the next important piece of the language at the bottom there is what defines a public record. Public records is, again, a fairly extensive definition. All records, reports, forms, writings, letters, that long list there that are pertaining to public business and having been prepared for, having been used by, received by, in the possession of, or under the control of any public body. And when you get into legal disputes, whether that's in court or otherwise just arguing with a local government, the issue that will most often come up is what defines when something is in the possession of a public body or when it pertains to public business. And that's something that I believe I'll be able to get to a little bit as we proceed. But again, if any questions come up at any point, please feel free to stop me. An example I can give here is something in the possession of just an individual city council member will not necessarily be considered in possession of the city council itself. And what the subject of the record is that's in the possession of just one city council member will also be important. If it's something that will be a public record, then that's more likely to be subject to disclosure at a later date. But if it's like a draft of an ordinance, let's say, that this council member wants to push at a future meeting, but it hasn't yet been circulated, that likely will not yet be in the possession of a public body. So you would have to wait until the record has actually fully been created. Again, hope this is somewhat self-explanatory. FOIA applies to public records, and that is public business. So what would otherwise be records in the possession of public officials, if their subject is purely private affairs, then that's not going to pertain to public business. And I think of the duty to obtain language on this slide in terms of, again, the public body as well, not the individual public official that may more easily have specific possession of something. And that's, if it's public business, then there's going to be a duty to obtain to actually conduct the business of the public body. Records, items within the purview of what the public body is typically responsible for. The definition is fairly extensive in it of itself, but there are some things that come up frequently, like settlement agreements, notices of denials of FOIA requests, certified payroll records, certain arrest report information, usually with some amount of the personal information redacted. Those are likely to come up frequently when you're dealing with FOIA requests. So in addition to the broader public records definition, those are set out specifically in the Freedom of Information Act as well. And there are, to be honest, a lot of public bodies that don't necessarily follow all of the rules in the Freedom of Information Act all that well, including that last one, that they must, by the law, make a reasonably current and detailed list of all types or categories of documents under that body's control available to the general public. Those should be on websites somewhere, posted in a city or village hall, for example. A lot of them don't do that, but that is something in the law that is technically a requirement. So if you're looking for an area to start with to improve your city, your town's FOIA policies, that is something I would hope that you would consider, because it's important, even if you don't see the long-term impacts right away. Just having that openness about what the procedures are matters quite a bit. So a question that has come up a couple times recently, including in something that I've been working on in my capacity at CAC, is whether and in what circumstances private emails or text, social media messages, when they're exchanged between public officials, would actually be considered public records that would be subject to full disclosure from a Freedom of Information Act request. For Champaign versus Madigan, they're public records if it's forwarded to enough members of the public body to constitute the quorum. The idea there is that if you're like individual members of a legislative body, like a city council, are not able to actually conduct public business by themselves, they don't have any authority to take direct action without the council meeting most of the time. So if they're sent during a meeting or forwarded to enough people that they could conceivably quickly take action on that, then even if it's a text from a private phone or an email from a private computer, if it pertains to public business, those records might be subject to disclosure under the Freedom of Information Act. The 2020 appellate court ruling was a little bit more narrowly focused. It dealt with public officials in the mayor's office in the executive branch of the city of Chicago, if I remember that case correctly, and private messages. I think there were emails in between different executive office employees there were found to be subject to disclosure under the Freedom of Information Act more immediately, because officials in those kinds of departments, like the health department, execute public business. They conduct public business without needing to have a quorum, that have a meeting requirements. They can just conduct public business unilaterally. So records pertaining to public business with employees that are able to just take action right away, those are considered in the possession of the public body for the purposes of FOIA. The question of who is allowed to file Freedom of Information Act requests, a running theme that I've noticed as I was preparing this presentation through a lot of the definitions of the law, is that most of these definitions err on the side of being extensive. There is no real limit on who can file a Freedom of Information Act request. If you are present in some capacity, not even necessarily physically, just present in some way where you have the access to governing body's Freedom of Information Act officer or their web portal if they have one, you can request whatever you like. You won't necessarily get a response, but you're allowed to file that request. Well, the question of privacy as it relates to names of and subjects of FOIA requests is a little bit of an open question. Something that I've noticed that's a little more common among bigger governing bodies that have the capacity, resources, tech know-how to put together some sort of FOIA portal. Often the names of the requesters, if they're left, and frequently and the subjects that they are requesting are frequently posted online. And it's a little bit of an open legal question what the exact status of privacy there is, but that is something that happens a lot. Now, commercial requests are, well, it's set out here. Commercial requests are FOIA requests made for any amount of sale, resale, solicitation, or advertisement. That's often not going to be the case with the kind of FOIA requests that citizens are usually filing. This doesn't come up very often. And the obligation to respond to commercial requests is still more or less the same. Some of the deadlines change, and if a public body is dealing with a commercial request, the level of fees that they can charge for actually processing that request goes up. There's not a whole lot of significance here that comes up very often, but again, if anyone has questions specifically on commercial requests, please feel free to ask them. Happy to address whatever you all want me to address. So the next bit of this first section will address what making available for inspection or copying means as it's used in the law. Excuse me. Copying means the reproduction of any public record by means of any photographic, electronic, mechanical, or other process. I haven't seen this happen personally myself, but what people are allowed to do if they actually desire to is, as far as like physical records are concerned, if there are no redactions that need to be made, you are supposed to be allowed to just inspect those records at the city hall, for example, and take pictures if you want to. The way FOIA requests are often processed now is, since just about everything is digital, papers are scanned, turned into PDFs, and whatever records you're looking for are sent back to you that way. I'm sure, Alyssa, imagine you haven't dealt with physical FOIA requests in quite some time.
I fortunately haven't dealt with any FOIA, but I think that when we do it, we do usually do it digitally.
That's where the way most records are kept nowadays. So that does cut down a little bit on the fee issue, but fees can still be charged if you're dealing with a particularly voluminous request, usually up to 15 cents per page, black and white. Most often, the pages up to a certain length, there's not going to be a fee attached to that. I don't remember the number off the top of my head, but if you really would only need to worry about fees if you're asking for a particularly huge amount of pages. And again, if a public body tries to impose a fee that's not consistent with what FOIA allows for, they're really not supposed to do that. But if they do, that is going to be considered legally a denial. And then that will lead us into the next steps for what happens after a denial that I will talk about in a little bit. Pause here for give folks a chance to. I've gone through a lot of information fairly fast. Pause here for 30 seconds to a minute if anyone has any questions.
Sounds good. So everyone feel free to put your questions in either the Q&A or the chat, whichever you're more comfortable with.
Best, I also kind of wanted a break from talking so I can take a few sips of my water. But I can keep going. Seeing no questions yet.
Nothing coming in so far.
There we go. There is an important part of this slide I want to highlight. There's a specific exemption from the fees I was talking about earlier. If the purpose is to access and disseminate information regarding the health, safety, and welfare or the legal rights of the general public. No copying charges unless the response was late. No search costs unless you're dealing with a commercial request. There are other statutes that may come into the equation here when you're talking about fees, but that's not likely to happen very often. And if you're requesting information that is actually available online somewhere, a public body is within their rights to, rather than giving you that information again, just direct you to where it is. But you do have a right to get some specific URLs for what you're looking for. Not just like, hey, search on this website, it's wherever. Like, no, they are supposed to give you the URL of where you can find what you're looking for. Bear with me. So just collecting my notes for a second, excuse me. I think if anyone has any further questions about electronic records, I can come back to that. Otherwise, I can just keep going. Except as otherwise provided in section 7 and 8.5 is the lead in to what the exemptions to disclosure under the Freedom of Information Act are. Private information, I think, is a sensible exemption. Doesn't necessarily often come up depending on what information you're looking for and what public body you're dealing with. If you're looking for records from like the school board, for example, there might be information related to students or addresses there that needs to be redacted. And the private information exemption will not usually result in you getting nothing. What's usually supposed to happen there is any of that private information that shouldn't be disclosed is redacted, and then you get the rest of what's subject to disclosure. Signatures and zip codes only exempt sometimes, depending on the circumstances. They constitute the unique identifier in certain situations. They may be exempt, again, usually disclosed with necessary redactions. Personal privacy is related, but could have some potentially different applications, although the way I've come to understand this exemption, there's a lot of potential overlap between what a public body might claim is exempt because it's private information versus what a public body might claim is exempt because disclosure would constitute a clearly unwarranted invasion of personal privacy. So law enforcement related records, I would encourage anyone who files a Freedom of Information Act request to be careful and take a critical eye to any time this exemption is claimed, because it's certainly important. There's no question about that, but this kind of exemption doesn't cover every single law enforcement record. For a record to be exempt under the law enforcement exemption, it needs to interfere with pending or actually reasonably contemplated law enforcement proceedings, deal with the correctional agency that's the recipient of the request, or deal with active administrative enforcement, create a substantial likelihood that the person will be deprived of a fair trial, or unavoidably disclose the identity of a confidential source. The ways that this exemption is supposed to be applied is set out in the statute, and it's not just a blanket that anything dealing with law enforcement is exempt from disclosure. No, it applies to specific situations. Again, this is some of the similar. I'm going to leave the slide up for a moment for folks who want to read it, and just make the point again that being careful if you file or someone you know files a FOIA request that gets met with this kind of exemption, because it's important and it covers some very important circumstances where redacting or not disclosing something could be particularly important for the well-being of the public body or of the community where the public body where the public body is. But this is one that could have the potential to be overused depending on which municipality you're talking about. So I want to leave this slide up for a moment if there's any questions. I see. I can take a time to answer this question.
Yeah, I see there's a question that just popped up. I'm going to read it aloud just for
Okay.
those of you who are listening rather than watching. Are there qualitative standards or limits related to FOIA requests? Red light camera footage I requested was sent by law enforcement as a cell phone recording, a grainy computer screen, and was too short. I was refused better quality or duration.
So I'll answer this in this way, that your remedy for that would be a little bit complicated to get into. But the way I read the Freedom of Information Act is that you have a right to, these records are like copies. So just if there's actual red light camera footage that was being played on, I'm not sure if I'm understanding the question correctly, but if there's red light camera footage that was like being played on a screen at the police station, and what you were sent was a cell phone recording of the screen that was actually playing it.
That's my understanding too, as to what he's saying, that when he requested it. Yeah.
I don't think that that's really complying with a plain text reading of the Freedom of Information Act. Like, you have, unless some other exemption applies, you have a right to these records, not to a recording, like an improper copy. I think is a good way to describe that, of these records. So if that's, I don't really know how to get into more of the detail of how you would address that, but I would say that situation that you described is a problem. And again, plug for the organization. If you want to figure out more about how to address that, please feel free to reach out to CAC.
Is there any sort of FOIA request that CAC wouldn't help with? Just curious, like something where it's like, oh, that's, like, let's say it was like something where it was obvious that someone was just doing something for, some sort of personal and not civic reason, or if, you had reason to believe that somebody was doing a FOIA and, maybe for the wrong reasons. Do you know what I mean? Like, I'm just curious how much CAC gets into like the reasons why people want to do FOIA as opposed to just helping with people doing FOIA.
So we try not to, as long as what is being requested is within the bounds of what the law allows for, because there are some exemptions, like what I went over. Like, if it's an unreasonable invasion of personal privacy, then it's like, well, regardless of whether we try to help you or not, you can't do that. You can't request that kind of information. You will not be given it. But my personal philosophy on this sort of thing is that, on the aggregate, having a clear policy that everyone knows, that maybe not everyone, but that the vast majority of people understand, know how to use, and know when to use, that's a net positive. So if someone's seeking to do something that is, in my opinion, within the bounds of the Freedom of Information Act, then yeah, well, we won't, I don't really see a need to dig any further than that.
Makes sense.
I appreciate both of those questions, though. I think I've left this slide up for a good deal. So the next little bit is going to be a hopefully fairly abbreviated nuts and bolts how to FOIA, excuse me, where you should be able to find the right place and procedure, what the request should look like. There's a slide coming up with a few samples of text that you might use for Freedom of Information Act request, and then what sort of responses you might get, and what comes after that. So this is another bit where public bodies, in my experience, have had a somewhat less than stellar record about making this information readily available. But if you're dealing with a village board or like the library or something, there should be somewhere prominently posted. That could be at the offices or at the building, excuse me. I think, considering the digital world that we're in, a more appropriate place to make sure this is all posted is in the building and on a website. A brief description of how one might file a Freedom of Information Act request and what public records might be subject to that. where it should go, address for where requests should be directed, if it's just like email a specific person, who that person is, how you can get in contact with them, either physical mail or email address, some sort of description of what kind of fees you might be looking at, and if there's a different method for dealing with electronic records versus other public records the body might have, that information is supposed to be made available for you as well. A lot of places aren't great at that, but this is a requirement under the law. Some public bodies are. There are just some that I've seen that are not really doing this. Here, I can leave this slide up for a minute. These are just a few examples of what language you might use for dealing with a FOIA request. If you send a general request, like all documents related to some event that happened, depending on the size of the body you're talking about or how significant that event was, you might run the risk of a lot of the records coming up as responsive to that. You might either get requests denied because it's unduly burdensome to comb through everything, or you might just get buried in a lot of papers that you didn't actually want. So the general request is fine, but just be careful with how you're using it. It could bite you. As specific as you can get, as specific as you can get, the more likely you are to get to the information that you're looking for as fast as is reasonably feasible. The specific request example up here is one way to do it. If you have a specific date you're looking at, the parameter-based request is another one that I personally like to use when I'm whenever I have a desire to FOIA something. You could get into some arguments back and forth if you proceed the question with documents sufficient to show, but that is a good way to make it clear to the FOIA officer that you're dealing with what specifically you're looking for, and that might work in some scenarios. It all gets very fact dependent which of these methods is going to be the most useful for you. But keep this slide in mind. If you want to go back to the YouTube after this is done to look for this slide, get in touch with CAC. I can make this available to whoever wants it. This is just a good place to come back to for when you're starting. The public body's response in general, they must respond within 5 business days. Public bodies have the option under the law to extend by another 5 business days, typically if they need it, although that's frequently overused. And quite often, I'm speaking mostly from experience with the city of Chicago, I should say, but it happens more than just that you will get a form letter just claiming the additional 5 business days immediately. And you may agree to additional time if, like, you have an actual communicative FOIA officer and you're having a reasonable back and forth. That is that is an option that could be available to you. Well, failure to respond by whatever the deadline is, whether it's something agreed upon or the statutory extra 5 business days, is considered a denial, and that rule applies in all circumstances, regardless of if there's personnel issues going on or budget constraints. The public body has the responsibility when receiving a FOIA request to undertake a reasonable search for whatever records are requested within the time allowed for by law. And failing to respond is considered a denial. Public bodies aren't supposed to just fail to respond. They are supposed to either give you some version of what you're looking for or give you a specific denial. And those specific formal denials need to have some requirements that are set out here. Like, if they're denying the request for a specific exemption, what the exemption is, really whatever the reason for the denial is, they need to make that clear to the requester. If there's a need to cite to legal authority, then they need to do that as well. If there's different people other than the FOIA officer responsible for the denial, they need to set that out. They need to make sure whoever's requesting knows that they can reach out to the Attorney General's Public Access Counselor's office, which I will go into in a moment, to basically appeal is what that is, or they have a right to appeal to the circuit court, which is just filing a lawsuit, and then you have proceedings in front of a judge if you go that route. I mentioned the undue burden exemption a few minutes ago. What that means is that this is another one that is sometimes overused, but the way the undue burden exemption is supposed to be used is when a public body receives like a categorical request that might, if they run a search through a digital database, for example, might turn up 3,000, 5,000, like 10,000 individual documents that they would need to sort through to actually find what you're looking for. And there is a balancing test that's supposed to happen here between the actual burden on the public body and the public interest in disclosure. And like all other exemptions, if this is claimed, the public body has the burden of supporting their reasoning and making their case. In theory, they're supposed to confer with the requester. Like if you're going to be hit with an undue burden exemption, what's supposed to happen is that the FOIA officer should reach out to you explaining why they think the request as written is unduly burdensome and asking you to narrow it in some way. And if they fail to respond to the request on time, whether within the initial 5 business days or the total of 10 business days, then a public body is prohibited from claiming this exemption. Excuse me. This exemption I kind of consider the troublemaker exemption, if you like. Recurrent requesters, there is this also shouldn't be being used very often, but there is an exemption built into the law if people are making frequent FOIA requests and there's not really a clear reasoning for it and a clear finish line of what they're actually looking for, just filing FOIA requests to file FOIA requests. The public body is not allowed to aggregate requests from spouses or a group. It's really like an individual person, not news media, not for nonprofit scientific or academic organizations. If it's just a person filing FOIA requests to file FOIA requests, they would fall under this provision. And they'd be entitled to the same records, but the public body is given more time to figure out how to deal with it. I'm not going to bore everybody by reading through everything that's on this slide, but I'll run through the deadlines really quick, just for folks who might be listening but not watching. Within 5 business days, they have to notify the requester if they're using the recurrent requester exemption, and that they have 21 business days to send some sort of initial response, which can include an estimated time to produce the records, a denial. They can assert the undue burden exemption and ask for a narrowed request, or they can respond. But instead of the 5 or 10 business days, they now have 21. And within a reasonable period, they must provide any non-exempt public records responsive to the request. And that's not particularly defined other than in any way other than this. Voluminous requests. That means a request that it's fairly self-explanatory as well. A request that gives you a large amount of responsive records. 5 individual requests for more than 5 different categories, or a combination of individual requests that total more than 5 different categories of records in a period of 20 business days, something that requires the compilation of more than 500 letter or legal-sized pages of public records unless a single requested record exceeds 500 pages. And like several of the other exemptions I've gone over, this does not include news media, nonprofit, scientific, or academic organizations making requests for those purposes. And here again, there is a modified deadline that they have to identify the request as voluminous within the 5-day deadline, and the requester has 10 days to modify or stand by the request, and then the public body has 5 days to respond to the modified request, and 5 days to provide an estimate of fees or assert undue burden or provide the records. again, with a voluminous request, you're more likely to run into some fees that might be significant. So there's an understanding that those would be brought to your attention first. So getting near the end here, there are really two paths that you can take if you're dealing with a FOIA request that has been denied. They can both end up in court, but one, you are allowed to go straight to court and file a lawsuit if you choose to. The other, you can file a request for review with the public access counselor's office as part of the attorney general's office. And then depending on how that process finishes off, you are still able to go to court after that. Or you can decide partway through that you change your mind and you want to go to court, and you can file a lawsuit, and the attorney general's office would take no more action. So really, choosing the PAC office does not prohibit you from going to court. It's just another way that might remedy your situation without costing you as much money. The PAC office is a bureau within the Illinois AG's office. They can issue binding or non-binding opinions in response to both Freedom of Information, well, not both, in response to Freedom of Information Act requests, requests related to the Open Meetings Act, or certain issues related to governmental ethics. The PAC must issue within 60 days, usually a binding opinion, and those are fairly rare, and courts will often defer to the reasoning on some of them. And if a non-binding opinion is not followed, the burden is on the requester to file their own lawsuit. The process, if you want to go to the PAC office, you have 60 days after the denial, or if you didn't get a response after the deadline passes, to submit a written request for review, which is subject to less formal requirements than going to court. You just have to explain what the facts are, what your request was, and why you believe it was improperly denied. The public body is then given an opportunity to respond, and then you're given an opportunity to reply to that response, and then you get a decision after that. This process can sometimes take quite a while. Usually several months is a low end. Sometimes it can take much more than a year. Again, a benefit of going this route is that it does not cost you anything. You are able to, in some circumstances, get whatever FOIA issue you're dealing with resolved. Although it's been a growing trend that public bodies ignore non-binding opinions because, again, if they ignore that, the burden is on the requester to go to court and enforce it, and that costs money, and a whole lot of other issues can potentially come up there. Another option, you can forego the PAC office if you choose to and just file a lawsuit. The court can enter an injunction, a court order requiring the public body to release the records that were at the subject of the dispute. That's another place where courts award attorney's fees and costs to a prevailing requester. Sometimes there's civil penalties if you're dealing with like willful and wanton violations, which basically just means if the public body either is aware or should be aware that they're violating the law and they continue to violate the law anyway. These matters, when they go to court, are supposed to be expedited, so it's not supposed to go into court. Another risk of going to court most of the time is that that'll take even longer than the PAC office does, sometimes years and years. FOIA matters are supposed to get faster treatment so that you can get more quick turnaround. And if the subject of your dispute with a public body is one of the exemptions I went over earlier, the public body has to prove that exemption by clear and convincing evidence, which is some legal jargon, but that basically means they have to make a very strong case, not just like, maybe they were right about their exemption, maybe they weren't. They have to have a good deal of evidence and strong legal reasoning on their side. So, and again, something I want to reiterate one more time, if someone takes their dispute over a FOIA request to the PAC office, they're able to file a lawsuit at any point through that, at any point in that process, if they choose to. And all that means is that the PAC office takes no more action and the whole dispute just moves over the court. So, excuse me, both of these are available to you. I want to give folks a moment to take a look at this quote and figure out who who said it if you know. And in the meantime, I think this is another opportunity to pause for questions if anyone has any at this time.
Feel free also to pop in the chat who you think might have said the quote if you want to have a guess.
Mm-hmm.
It looks like we've got a guess of Thomas Jefferson. Ooh, somebody guessed Abraham Lincoln. So definitely people are thinking presidents.
I will tell you that the idea to put this in this slide didn't come from me. It did come from one of my predecessors at Citizen Advocacy Center, and I did not recognize the quote myself. My guesses were wrong.
Ooh, we have a guess of Ben Franklin. All solid guesses.
Any other guesses? Going once, going twice. Ironic, isn't it? A quote about the importance of public access to information, trust in government would come from someone like Nixon, who didn't have a great track record of actually conforming to those principles. But the point of that quote, I think, was right on the money. Access to information is at the core of public trust. And like I said at the beginning of this presentation, without public trust, we can't really have participation in our democratic system, at least not in any meaningful way, and the whole thing will really collapse. So things like the Freedom of Information Act, things like citizens using the Freedom of Information Act to keep their government honest, whether you're talking about the General Assembly, whether you're talking about the federal government, whether you're talking about your city council. At all levels, it's incredibly important. And I know there haven't been many questions throughout, but that is the end of this presentation. So I will, before inviting any further questions, I will just say, again, if you have any interest in hearing any more about the Freedom of Information Act, because I went through a lot of information fairly fast, if you have a specific issue you would like some consultation with, or you just want to learn more about what CAC does, please make as much use of this contact information as possible. Happy to talk to anybody about any of these issues. And I know we're done under an hour, but if there are any questions, any lingering thoughts at this point, happy to take them now.
Anyone pop anything in the chat or in the Q&A? I'm curious, how many lawyers work with CAC? Is it just you there, or are there other people too?
Well, I'm the only one on staff right now.
Mm-hmm.
We have an ongoing search for a new executive director who, in addition to doing the nitty-gritty of running a nonprofit, will also be a community lawyer like myself, who will take on some of the similar work. And we have a board of directors who are great. They stay involved in the organization. We have several volunteers who are lawyers in and around DuPage County, who, while having their own practices, get involved as much as they're able to help the mission of encouraging civic advocacy. So on staff, there's just me. If you count total, there's several, and I don't know the number, but there are quite a few. The services that CAC provides. So I still have a bit of a hard time briefly summarizing that, giving a brief answer to that question, but really anything that would relate to civic advocacy, relating to your ability to make your voice heard with a library board, maybe, or with like a zoning issue for within your city council, or just understanding what the Freedom of Information Act is, what the Open Meetings Act is, what ethics rules apply to government officials at different levels. There's a good deal of education that happens. A lot of what I do, the way I understand it, is encouraging people to become community organizers, to get a group of folks together to figure out what sort of change they might want to see in their community, And then CAC exists as a resource to help that group figure out what steps they need to take, what possible pitfalls there might be, and how to maneuver around them. Kind of 50% community organizer, 50% lawyer is something I like to say about how CAC operates.
And what is the geographic area that CAC covers? Because I know obviously you're located in Elmhurst, but you also mentioned Chicago.
So the most of the people that we interact with are in DuPage County, because that's where most of the people who know about CAC are. However, there's the real geographic limit is if it would be feasible for me to drive out to meet someone. So that could include most of the collar counties, Cook County. Probably not much further out than that, but like DuPage, Cook, Lake, Kane. Most of what happens is in DuPage, but the possible service area is quite a bit larger.
Sounds good. Let's see, any more questions? Oh, here's something. If Will County is too far, who would be able to provide similar services?
I'm not sure if Will County is too far, but
there's parts of, I was going to say there's parts of Naperville that are in Will County if you don't know offhand where Will County is. So think like that direction.
Yeah, I'm not, Will County might kind of be on the outskirts, but I think that would still be included.
It looks like Joliet specifically is what she said. Joliet.
Oh, yeah, Joliet's not too far. But we are hoping to expand the idea of community lawyering, people with legal expertise, legal background, community organizing background, spreading the wealth, spreading the resources, because the more people who have the capability to take these kinds of actions, hold government accountable when they feel the need to, the stronger our democratic system is, the stronger our society is. So encouraging more people to start organizations like CAC is definitely a goal. Definitely an ongoing conversation that I can't really do justice to here.
So someone in the chat says, thanks, first exposure to FOIA and CAC. And someone, oh, sorry, go ahead.
No, I was just going to say, thank you, Judith, for joining us tonight.
All right, here is another question in the chat. Someone says, I called 911 having stumbled onto an unconscious youth late at night on a popular local bicycle route. Police and EMS arrived and attended to the individual. Do you see this as too sensitive or private a matter to request anonymized or redacted info about? I'm just wondering if he was okay. If so, would this be submitted to the municipal FOIA officer?
So I would say if you want to have like a more in-depth discussion about this, send me an email or give me a call. But to give a brief answer, I think that this would be a scenario where, like, if you just want to see if the kid's okay, I would suggest you don't necessarily need to go the FOIA route right away. It might be a call to the, well, it depends a little bit on how big the police station is, but I think you might make a call in to like a non-emergency number, say like, hey, like, I know this happened. I just want to see if everyone involved is okay. And you might be able to just have a conversation there without getting the formal legal apparatus involved. But if that doesn't work, then yeah, the municipal FOIA officer would be where you would go with that. Yeah, the municipal FOIA officer would be where you would go if you want to go the formal route.
All right, someone else says, thank you for your work and for this excellent presentation. So go you.
I want to, I'm sure there's a lot of other better things, well, a lot of other more entertaining things that folks could be doing at 7 to 8 on a Thursday night. So thank you everybody for taking the time to learn more about the Freedom of Information Act and civics and how important all of this is. So I don't know if there's any sort of formal sign off you need to do, but
yeah, so my formal sign off is just mentioning that this will be on YouTube. As of now, I don't think there were any tech issues with the recording. It seems like it worked just like it was supposed to. So we usually have things up on YouTube within a couple of weeks, and then anyone who was registered for the program is going to get emailed a link to it. But then it'll also just be on YouTube if you want to share it with friends or anyone else. And yeah, I think that's pretty much it. So unless it looks like there's no more questions trickling in, but fortunately, if you think of questions, Citizen Advocacy Center, it sounds like, is willing to help you.
Screenshot this
Yep.
screen if you want.
Yep. Or just go to the website. I was able to find contact info on the website, so that works too. And all right, I think we'll call it here. Thanks so much for coming, everybody.
Thank you for having me.